material was struck off. You accept that?
I'll certainly accept it and ask Chair to note the final outcome of these judgments, which is quite damning of the public protector and her bias. And if you refer to, in the 7th of December judgment, paragraph 290, subsection 5, or subparagraph 5, for example, the public protector's pandering of the rogue unit narrative and a public reference to the unit as a rogue unit, inverted commas, and as a monster, inverted commas, and a stated desire to defeat the monster, inverted commas, display a profound bias towards Mr. Gordon, or Minister Gordon, and accidentally they say Minister Pillay, but Mr. Pillay.
Yeah.
So like that, there are various comments in paragraph 290 on the conduct of the public protector.
Effectively, what you are saying is you accept that the court was critical of you, but you are simply saying you were not the only one of whom it was critical.
Certainly. Thank you.
Okay.
Yeah, but you're the only one here. I mean, what has that got to do with it? You are the only person who's being accused in this cross-examination of bending about accusations and insults at people without evidence. So it doesn't matter if 1,000 other people were accused of the same thing. Anyway, at paragraph 210, or page 210,
of the last mentioned judgment?
Yes, of the last mentioned judgment, Chair.
Page 210.
210, yes.
Okay.
It says...
What paragraph?
89.
Yeah.
It also says, when the amendments made by the applicants in paragraph 38, 39, 40 are considered, whether individually or cumulative, they can be construed as nothing else but gratuitous averments based on suspicion. The averments are therefore vexatious and made intending to annoy the public protector. A similar finding based on allegations couched in similar terms by Minister Gordan had been made in the other case in the rogue unit case, at paragraph 267 and 268. We've already gone through that. Is it fair to say that these two judgments, while they might, as you say, might have been scathing about other people, were also very scathing about your penchant to bandy about insults and vitriol and gratuitous averments without any evidence, and in doing so going overboard, as the judges said, and spewing averments that are not supported by evidence? You agree?
Chair, I confirm what the paragraphs in the judgment say, and equally, the judgment doesn't refer to other people. It refers to the public protector. And finally, both judgments find against the public protector. I accept the paragraphs that Mr. Mpofu refers to, that being that there were criticisms of one or two paragraphs in my affidavit.
No, not one or two paragraphs. And do you accept that in respect of this aspect of the case of bending about gratuitous insults to people, both full benches, in other words, all the 6 judges actually found against you in favor of the public protector?
Chair, again, I'm not a lawyer, but when I read paragraph 290 onwards, I don't find any commentary on those things.
Okay. I think it's obvious that you did not either read these judgments or they were not given to you. The order that was at 273, Chair?
What page?
273.
Okay. Yes.
Okay. So again, as I said, it's not one or two paragraphs. It says order 3, Chair. The striking out application, which was brought by the public protector, in terms of 615 application is granted, in other words, in favor of the, against you, in respect of paragraphs 38, 39, 40, 53, 54, 55, and 70 of Minister Gordan's affidavit. Do you remember that?
Chair, there are two judgments. The one is the 7th of December 2020, and the other is a judgment, I think, of the 19th or thereabouts of December 2020. I think it would be extremely helpful if we know which judgment we're referring to. When
Well,
I quoted
There's only one judgment that's on 273.
Can I finish, Chair?
Yes, he's referring to the last mentioned one, which
Which date?
which was written by Judge Kubushi, Judge Twala, and Judge Davis. What page does it start on?
273, well, okay, where it starts, Chair, is
That's, are they, or is the one with 3
165.
judges? Is the one with 3 judges?
well, they both had 3 judges.
Or did they both have 3 judges? I thought
All
it
the
was
judges
2.
found the same thing against Mr. Gordan. The first one was Judge Pakwa.
Do you want to just clarify, are the parties the same? Because that's one way of distinguishing.
No,
Or say what page where it starts. It's a long judgment.
well, yes, the first one Chair, ends at 160.
Or let's go to the second one because that's the one you are asking about.
Yes, that's one I was
Where
asking
does it
about.
start?
Starts at 168, I think. 165.
165. Okay, it starts at 165, Mr. Gordan, the one that, yeah, it's.
I was reading at 273, Chair, so I don't
Yes,
know
I
why there's
see.
confusion.
It doesn't have, the one I have doesn't have the date at the beginning of when it was given.
Yeah, the date you'll find at 275, at 275.
Yeah. Do you see which one we are talking about, Mr. Gordan? If you have got the page, it starts at page 165. It's where you were the first applicant, and Mr. George Ngakane Virgil Mahashul was the second applicant, and Mr. Pillay was the third applicant. And Mr. Mpofu was reading paragraph 3 of the order at the end of the judgment.
I think you're muted.
Looks like,
You can proceed. I'm looking at my computer to try and track it down.
but I can tell you that the paragraph 3, really says that the application brought, I think, by the public protector for paragraphs 38, 39, 40, 53, 54, 55, and 70 of your founding affidavit should be struck out, was granted. That's what it says. So Mr. Mpofu wanted you to confirm that you know that that's the order that was granted under paragraph 3.
Since you've read it for me, Chair, thank you very much, and I note that.
Yes.
Thank you.
Okay.
Okay. Well, more importantly, the paragraph 6 of that judgment was that the first and third applicants, and you were the first, are ordered jointly and severally to pay the costs of the Rule 615 application, including the cost of 2 counsel, on the scale as between attorney and client. In other words, on the punitive scale. So the court decided to award punitive costs against you for the insults, the gratuitous insults that you had held without evidence at the public protector. Do you remember that, or was that explained to you, why you had to pay punitive costs to the public protector, even though it was not covered in the media?
I note the observation, Chair.
Now, with the further confirmation of at least 6 charges within a week or 2 after we had been here, you not only were told that you made false accusations of corruption and criminality against someone twice by 2 full benches, but you were also mulcted with punitive costs for doing so. So So that seems to be your propensity. What do you say about that?
That seems to be.
Your
May
propensity.
I respond to that?
What was the answer, Mr. Gordon?
No, there wasn't a question, but the allegation was that that is a propensity, which I deny.
Yes, yeah.
There was a question. I said, do you agree with that?
I
Yes.
deny that
Yes.
vehemently.
And it was also said that, you remember we had our discussion about racism and belittling people and so on in November.
Yes.
Do you know that, again, 3 judges, Judges Kubushi, Twala, and Davis, a few weeks after the last cross-examination, found that your attitude was condescending towards an African woman, namely the public protector.
Can you refer me to a paragraph, please?
So if I may. 145. That will be the second judgment at, sorry, Chair, if I may just get my reference. 8. Yes, page 205. Paragraph 78. And in relation to that one, you had made an allegation that, similar to the ones you made against Mr. Moyana, that the public protector was motivated by state capture and corrupt motives in issuing her report.
I'm sorry, where are you reading from? It's not in 78, is it?
Sure.
Where are you reading from?
I'm not reading, I'm just talking.
Oh, okay. I thought you were referring us to page 205.
Yes, I am. I'm
you are not
just
reading
telling,
yet.
giving the witness context. Yes.
Okay, okay.
In that regard, you had accused the public protector of being motivated by state capture motives for issuing a report against you 48 hours before the announcement of cabinet or the inauguration. You remember that?
But where is the question of race in paragraph 78?
Do you remember just answer the question, Mr. Gordan. Let's not start on
No, Chair.
Don't ask me
Chair,
questions.
with great respect, Mr. Mpofu first referred us to paragraph 78 to illustrate his point that there is a so-called racism in my conduct. And I said, where is the paragraph? He then refers to paragraph 78. Now, for the public record, Nowhere in paragraph 78 is the issue of race referred to. That's the only point I'm making.
No,
I'm sure you can see it in front of you as well, Chair.
Yes, no, my recollection is that he didn't use racism. He said condescending, and if you look at paragraph 78, there is a reference to condescending.
He said condescending towards African people.
Black woman, I think.
No, he referred to African woman.
Yes.
Chair, he referred to an
Mpofu,
African woman.
Just
Nowhere in
repeat your
paragraph 78 is.
Let's start with the question that you put first, so that I can know whether Mr. Gordan's answer is to the point or not. Or
No,
his
well,
concern.
Chair, you can know that for sure because it's not to the point. I've asked him a question. I'm
Yeah,
taking him
what
to
was the
the
question?
paragraph. I said to him that, does he remember that one of the judgments found that his attitude towards the public protector was condescending? And then he said, what page? And then I'm taking him to the page.
Yes, but you didn't read the page, the paragraph.
No, I've not read the page yet.
Yes, yes. You
I mean,
put
I
a
don't know what's
question
going
before
on
reading
now.
it, isn't it?
Pardon?
Did you put a question to him before reading the paragraph?
Yes, I put the
Yes.
question. He said he wanted the page. So that's why I had a break to look for the page. Now
Okay.
I've found the page. I'm continuing with my questioning.
Okay, all right. Let me read what the paragraph 78 says.
No, Chair. No,
It
we're not
is-
there yet. We're not there.
Yes, but why are we coming here if you are not going to let us
Because
read it?
I need to build up to the question that I've asked him.
But I thought there is a question you put to him after he had said, refer him to the relevant page. And that's the question that I think I missed.
Mr. Gordan, if I may ask, Chair,
Yes.
I was just giving you the background, and then you butted in and asked me a question, which is not allowed. What I was saying is, in relation to this questioning that I'm about to ask you, it was in relation to an averment made in your affidavit that the public protector was motivated by state capture and corrupt motives in issuing the report. Do you remember that?
No, I don't. I think what I remember, Chair, is that the issue was how does a public protector arrive at a final report within 48 hours of receiving some submission or the other?
Yes.
The court, on the other hand, notes in paragraph 78 that it is also condescending of the applicants to want to argue that the public protector would be unable to deal with their representations within a limited period of time of 48 hours. The court, that's the court's view. I note the view. It's recorded in paragraph 78, but there's no reference there to African women.
Nobody said there's a reference to African women in the paragraph. I said the court said your attitude was condescending towards her, and she is an African woman. You understand that? Do you know that the court said you were condescending towards Advocate Busisiwe Mkhwebane, who happens to be an African woman?
The word condescending is in paragraph 78. I've read it out already. I've acknowledged it, Chair.
Yes. And all I wanted to say to you is that again, a full bench confirmed that you belittling and condescending in the context we're talking about, it means the same thing. Belittling somebody and calling them cheeky and telling them to grow up is also condescending. Would you agree?
Not necessarily.
Sometimes?
I beg your pardon?
If you say not necessarily, I don't know what that means. Is it sometimes condescending to belittle someone and call them cheeky and tell them to grow up? What do you mean not necessarily?
I'm not sure about this line of questioning, Chair. So I note what the advocate says, but I have no response to that. On the previous occasion, I denied any allegation of racism, and my whole history as an activist of 50 years proves that as a member of the African National Congress, which subscribes to the Freedom Charter. That is all I have to say.
Well, he was asking you whether you equate calling somebody cheeky. What was the other?
Grow up.
Grow up when you say that to somebody, whether you equate that to condescending.
Not necessarily, Chair. I mean, you could have your child behaving badly and you say to the child, grow up, stop behaving like that.
Yes.
Because you are behaving childishly.
Yes.
Or on the other hand, somebody, including a child who might be particularly impudent on a particular matter, could be told you are being cheeky. So there are many different contexts in which those words could be used. And that's all I have to say.
And if you, yes, I agree with that. And if you use it in relation to someone that you have agreed is of the same age group as you, would you agree that it can be condescending for someone of my age
No.
group? It can never be condescending for someone of my age group to tell me to
No,
grow
no,
up and
no,
that I'm
not-
cheeky.
not in the context
Are you
of-
being
Chair, could
serious?
I place
Hang
an
on,
objection on
hang
the
on.
record? Chair, could
Yes.
I place an objection on the record?
Yeah.
2 points. One, Mr. Mpofu is now reframing his question. This all started because he stated as a fact, and the transcript will show it if we have to go back and look at it. He stated as a fact that the full bench found that Minister Gordan discriminated against an African woman. The minister then asked for the paragraph, we got referred to it.
Yes,
the
but you're going
condescending
back
claim.
now. We were
Chair,
That's
now,
not true.
if I can make the second point, now because of how the conversation is unfolding around the condescending word in that paragraph in a judgment that everybody accepts says what it says, we're now going back to the racism topic that was canvassed at length the last time. Mr.
Yeah,
Mpofu
but
is
he's
halfway through his
canvassing, but
time.
he's canvassing it now in the light of the judgment about condescending.
Yes, but Chair, the
Yes.
point is, what he's supposed to be using his hour for, and he's now halfway through that, is to deal with deflecting from your own involvement in state capture, the allegation made against Minister Gordan, and because and discriminating against Mr. Mariani because he blew the whistle.
remember that-
Now we're back to the conversation
But
on the
remember
transcript
that
of the phone call.
remember that if he doesn't use his hour optimally, it's his. It's,
Then he's going to ask for another
He has been given an hour. Mr. Mpofu, continue.
Yes, Chair, and I hope this mighty waste of my time will not be calculated in the hour. Because I don't know why my learned friend feels the need to lecture me about how to conduct my cross-examination. So, anyway, incidentally, we're still on the topic of condescending, which seems to be coming from all quarters.
Chair, can I object to that as well? Mr. Mpofu is doing his job, I'm doing my job. We don't need to make it personal. He doesn't need to take sniping attacks at me, at the evidence leaders, etc. If he just asked questions on the one issue remaining, we could actually get out of here tonight.
Okay.
Chair, I do not need Ms. Leroux to tell me which question to ask and when and why. Really, this is my cross-examination. She must just sit down.
Okay.
Okay.
Let's continue.
Thank you, Chair. Anyway, the question, Mr. Kotani, really is a simple one, that these judgments seem to confirm that it is your propensity, A, to insult people in a vitriolic, scandalous manner without evidence, and B, that to be condescending towards them. What's your
I
comment?
deny that completely and emphatically.
You don't think this judgment says you are condescending? What is it that you're denying?
The word propensity, which you conveniently introduced.
Oh, I see. So it just happened that two full benches found your remarks to be vexatious, insulting, vitriolic, gratuitous, all the words that I've used. 6 charges. That's just doesn't show any propensity. It just happened in front of those 6 charges. Is that your evidence?
Chair, there are 2 judgments that comment in a few paragraphs on language used in an affidavit, as opposed to many paragraphs with reference to the substance of the matter. And the substance of the matter is the conduct and the outcomes of that conduct in respect of the public protector, parts of which I read in the one judgment on the 7th of December from paragraph 290 onwards. In both judgments, the courts were completely condemning of the outcomes of and the findings of the public protector, including indicating displays of bias towards Minister Gordon and Mr. Pillay. And I quote from the 7th of December, paragraph 2090. So I think what we're asking for is balance so that we can move on to the next question. Thank you.
Mr. Mpofu.
Okay. The public protector is not under cross-examination now. I'm cross-examining you, Mr. Gordan. Do you understand at least that?
Oh, certainly. But
Yeah.
I think, Chair, the only point I'm making is that it's important to give both context. I think I heard you say that before to a previous witness, and the specific matter that you might want to refer to. The context is a judgment as a whole and the findings of the judgment, and the specifics is 1 or 2 paragraphs. That's the only thing I'm pointing out.
Anyway, do you accept that part of your evidence was that in reaching the conclusion that Mr. Moyane was a state capture practitioner, you relied, among other things, on gossip?
Yes, I understand I used that word, and I apologized for that, and understood once the transcript was actually referred to. But there are many other factors that, in retrospect, one can refer to in relation to Mr. Moyane and state capture. But if the chair wants to get into that, we can get into that.
Do you even
I must just mention, Mr. Mpofu, I know when you are on your feet, you might not keep an eye on the time. It's about 13 minutes past 7.
Yes, Chair,
Yeah.
but I mean, if I'm getting answers like this, I've asked you a simple question. Did you rely on gossip or not?
No.
So why did you say you relied on gossip?
Well, the word gossip was used loosely, which I explained then.
So which is which? Did you rely on gossip or did you not rely on gossip?
Chairperson, we have a repetition of the same question in different forms. But if I may, the word gossip, as I said, was used. And later I understood that, or tried to explain that gossip is basically saying that was information at that time. However, I think what Mr. Moyane needs to answer to, that was quite evident, is that
No, Mr. Gordan. The question is, did you rely on gossip or not? And it's either yes or no. No.
I had some direct information, which I have now recollected. At that time, I did use the word gossip. That's noted, Chair.
Okay, all right.
I didn't ask you about using a word. I said, did you rely on gossip, among other
And
things?
the answer which I've given already, Chair, is not entirely.
Okay, you partly relied on gossip. Okay, that's fine. I can live with that. All right. Now, you were then accused by Mr. Moyane of criminality. Do you accept that? Do you know about PRECA, the act that says that if you know something about corruption, if you don't report it, you yourself are guilty of a crime?
Vaguely, yes.
Yes. And you yourself knew, you testified earlier that you knew about Mr. Moyane's involvement in state capture, stroke, corruption, and all those things as far back as 2016, correct?
Yes.
And have you ever reported that to the police?
As I explained earlier, Chair, when Mr. Mpofu was referring to criminality and corruption and so on, in defining state capture, I said it goes beyond just those elements. So state capture is not only about criminality, it's about, for example, hollowing out an institution of its senior and most capable people, hollowing out people who have institutional knowledge, breaking up those parts of the institution that in this instance had to deal with cigarette and tobacco smuggling and other forms of illicit trade which harm the South African economy. And I think I've presented that to you as well as chair on a previous occasion. And dismantling the executive committee, for example, that existed at that particular time, and centralizing power. Earlier today, I believe you heard evidence about a central procurement entity, which was quite fascinating, because that's the easiest way in which to engage in the kind of activity that Mr. Mpofu is referring to, which is criminal conduct in relation to procurement. So state capture goes beyond, inverted commas, criminality. It is institutional damage on a wide scale in respect of governance, in respect of the operations of an organization, in respect, in this instance, of the revenue collection. And there are commentaries from the Treasury in that particular regard as well, and damage caused to the human resource capability that an institution has. So it's a much wider scope, if you like, to the definition.
Mr. Mpofu.
Well, I don't know if you or even the chair remembers what the question was. It was a simple question. I don't know what you've been going on for 5 minutes. Do you remember what the question was?
The question was whether I had reported any corrupt activity in relation to the PRECA Act. So A refers to the Act. And what I was explaining to you is the difference between criminality on the one hand and state capture on the other hand as a wider concept.
And when are you going to answer the question?
So I'm saying
did
that
you,
there was not
or did you not report the matter to the police? I mean, really.
I beg your pardon?
Did you, Pravin Gordan, report a matter of involvement of Mr. Moyane in state capture to the police? Yes or no? I mean, you don't need this 10 minutes of rambling.
As far as I know, Chairperson, and I'll be guided by yourself, state capture in legislation is not defined as a crime.
Chairperson, really, I have to intervene.
There might be specific.
Did you report the matter to the police or not?
Report what?
The matter of Mr. Moyane's alleged involvement in state capture. That's what the question is. Did you report Mr. Moyane's alleged involvement in state capture to the police?
But there have to be singular acts of corruption, which at that point in time I couldn't identify. Subsequently,
so the answer is you
there
did
were
not.
acts of corruption around giving a debt management company a contract to collect debt.
Yes.
But no, I didn't report it because I didn't see it within the purview of state capture.
Thank you. So the answer is no.
I think that's what you heard.
Thank you. So what was the last 10 minutes about? All right. Now, the PFMA, you were a minister who was responsible for the PFMA as Minister of Finance. So you should know it in and out, correct?
I'm familiar with it.
Yes. Now, when I'm going back to the issue of the rogue unit and the letter you wrote to Minister Manuel, it's fair to summarize that your letter was simply saying that SARS did not have the legal mandate to form such a unit, correct?
As originally envisaged, yes.
And that was from legal advice that you obtained, correct?
I can't remember the details.
Okay, anyway, maybe you just knew it, but you knew that it would be unlawful to form such a unit without the involvement of the National Intelligence Agency, correct?
So it would be illegal to
form a unit such as that one without the involvement of the National Intelligence Agency. Hence, you wrote a letter to Minister Manuel to that effect, correct?
No, the letter to Minister Manuel was to explain why cooperation between the intelligence agency and SARS was necessary, firstly. Secondly, why the unit need to be located within the NIA. Thirdly, to explain what the necessity is for that activity. And fourthly, to request finances for the unit, which was the burden of the memo.
No, okay. Did you say in your letter and said TSM 375, Chair?
I'm sorry, did you refer to a particular page?
375.
375.
Did you
That
say?
is, yeah, okay, continue.
Did you say collecting tactical intelligence is invariably means penetrating and intercepting organized criminal syndicates? This is an activity for which SARS does not presently have the capability, including the legislative mandate to manage clandestine activity. Did you write that? Signed, Pravin Jamnandas.
Yes. Yes.
So then your answer is yes, you knew that SARS did not have the legislative, it would be unlawful for SARS to do something that it did not have a legislative mandate to do, correct?
As I explained earlier, Chair, that was correct.
Yes. So if you, and did this money, was this money given by Treasury?
I can't recollect now.
You can't recollect. Well, if it
But
was...
it couldn't have been on reflection because that memo and its intent were not pursued.
Yes, so it could have been. And if it
No,
was...
I'm saying the opposite.
You're saying the money was not given as a fact?
I'm saying it's unlikely to have been, any money is unlikely either from SARS or from the fiscus to have been made available because as the transcript will show in the November cross-examination, this unit didn't materialize in the form that it was envisaged in that memo.
No, but then but the unit was formed, it was operating within a few weeks of this letter, which was in 2007.
It was a different type of unit with a different mandate in accordance with the SARS mandate.
No, but that's not the evidence of the KPMG report, the Sikakane report, the Kroon report, all found that it was unlawful for SARS to breach its mandate. And you knew, at least in 2007, that forming such a unit would be breaching its mandate. Correct?
The Sikakane report has been found to be incorrect in its judgment. And paragraph 290 of the High Court judgment on the 7th of December says that the public protector completely disregarded the Sunday Times apology and the Kroon apology. So the Sikakane report, Chair, was discredited. The KPMG report has been mutilated and disowned. And as far as Judge Kroon is concerned, he apologized for the hastiness with which he issued a statement and apologized for the contents thereof. So none of the three have any legs left at all.
Okay, let's take that bit by bit. You accept that the Sikakane report has never been reviewed and set aside or challenged in court?
You remember
Yes.
he answered that earlier, Mr. Mpofu.
I've answered all of
he
those
says,
questions in the
okay,
previous
maybe let me
occasion.
take you. Are you serious that the Sikakane report was discredited because the Sunday Times or something found it to be to have weaknesses?
Sorry, Chair, I'm talking about the 7th of December full bench judgment of the Gauteng North Court under paragraph 20, subsection 6. It says, the public protector completely disregarded the Sunday Times apology
Yes.
and the Kroon apology. And then earlier in paragraph 3, the reliance on the discredited KPMG report, despite it having been disavowed, and the Sikakane report, despite it having been widely discredited. She also failed to engage with the findings made in the Nugent report. This is quotations from paragraph 290.
Yes. Mr. Gordan, do you accept, okay, at some stage, I think you were a socialist, so you should know the concept of time and space. Do you accept that you are not a prophet? In other words,
Never claimed.
well, I know you count yourself as one of the angels, but you have not yet counted yourself as a
I
prophet.
didn't say that either.
Okay. Now, do you accept that up until the 7th of December, or whatever the date was, and by the time we had ended our cross-examination, and for 7 years, or 9 years actually, since 2007, the formation of the unit, what you knew was that it would have been unlawful and in breach of the law, and that was confirmed by these 3 reports. You did not know prophetically that one day in 2020 there would be a judgment, did you?
I don't claim to be a prophet, Chair, at all.
Good.
However, I do want to bring to the attention of the Chair that Mr. Moyane did ask for an opinion from advocates Trengrove and Ngumalo, which opinion essentially said that the line of reasoning in Sikakane was wrong in respect of the lawfulness of the unit.
All right. And do you know that Advocate Brasi found that your authorization of the Pillay retirement was unlawful, since you are talking about advocates' opinions?
I'm not aware of Mr. Brasi's view on that matter.
That's what he found. And also, are you aware that there was another report called the Kanyane opinion, which also found that your authorization of the rogue unit was unlawful?
The Kanyane report dealt with, I beg your pardon?
That also found that your authorization of the rogue unit was unlawful.
Can you read the relevant section for me, please?
Do you know or do you not know that there was another report called the Kanyane report which found that the rogue unit authorization was unlawful? Do you know, don't you know, yes or no?
No, I'm familiar with a so-called Kanyane report, and if you're referring to it, all I want to know is where does it say that?
Okay, I'll get back to that report. So are you telling this commission that you don't know that it found that your, like the other 3, like Kruan, like KPMG, like Brasi, like IGI, that it found that the rogue unit was unlawful, or rather your involvement in it?
As far as I understand it, Chair, the Kanyane report didn't refer to the investigative unit.
We are 3 minutes away from the end of the hour, Mr. Mpofu.
Yes, and did you know that the person who should know more than all of us about this, that is the Inspector General for Intelligence, found, and Chair, you'll find this at TSM 354.
Did you complete your question, Mr. Mpofu?
No, I was just
okay.
taking you to the reference.
Okay.
I was,
Say,
unless if you're already there.
354.
351. Let's start at 351, Chair.
Okay. Okay, I've got 351. Have you got it, Mr. Gordon?
I don't need it, Chair, because
you don't need it. Okay.
I have a comment on it once the question comes.
Yes.
Okay.
Okay, I'm reading from the report. Once again, you can take my word for it. It said...
Now, but if I can intervene, Mr. Mpofu, sorry.
Yes.
Chair, this report was taken on review and set aside by a court.
Yeah, but let's wait to hear what question Mr. Mpofu wants to put.
Again, you are pretending to be a prophet. I'm saying to you that at that time when you engage in these illegal activities, you could not have known, unless you are a new prophet, that in 2020 something was going to happen. Anyway, the report says, paragraph at TSM 351, quote, moreover, it is clear from the project Snowman document that only Mr. Gordan, Mr. Pillay, and Mr. van Lochenberg sanctioned this unit. There was a clear intention to keep the unit and its real purpose hidden from scrutiny. You remember that?
I'm sorry, Mr.
Oh, I'm sorry,
no
Chair.
comment,
It's
Chair.
just the end of paragraph 3.
End of paragraph 3. Okay,
Yeah,
all right.
just the last
Okay,
sentence. Yeah.
Okay, all right.
You remember that, Mr. Gordan?
No.
Okay, then it also said at the next page, 353, there is paragraph 7, Chair. There is further corroborated evidence to the fact that SARS, knowing fully well that it does not have a mandate to conduct covert intelligence collection in support of its activities, approached the NIA with a view for the NIA to establish a dedicated covert capacity under the aegis of NIA, subject to signing of an MOU between the two institutions. However, the MOU was never signed and the proposed dedicated covert intelligence capacity never took off. It is against the aforementioned background that SARS then took it upon themselves to establish a covert intelligence capacity, considering that the proposed initiative with NNA was not successful. You remember that?
No, and I deny that it was covert, firstly, and secondly, Chair, I need your guidance on this. There have been a number of insinuations about criminality on my part, and yet another one in this context was mentioned, that I engaged in illegal activities. Now, I don't want to take up the Commission's time, but at the same time, I don't want my integrity attacked, and I don't want to be insulted
Yeah.
Okay.
by
Yes,
use
I
of
think-
words like prophet.
Yes, I think.
I strongly object to that behavior.
Okay, can I assist, Chair?
Ask the question, you will get an answer.
No, let
Ask
me
the
assist
question
you.
and you will get an
I
answer.
will pause. I'll pause.
Hang on,
and go to the criminality.
Mr. Gordon. Your counsel is listening and she will get a chance to re-examine. So she might get you to clarify some of the issues. Mr. Mpofu, your time was up before Mr. Gordon, but I think I'll let you finalize one more question. Or you clarify that one, but we are at the end.
No, Chair.
So it's just that Mr. Gordon was in the process of asking and then he asked for guidance.
Yeah, well, Chair, I should think that I'm entitled to finish this topic at least. And with all these unnecessary interruptions, Chair, and ramblings on, I hope you've taken that into account. Because about 15 or 20 minutes of my time has been wasted by both Mr. Gordan and his counsel.
Okay, just
So-
ask, but
Yes.
it's extra time is 5 minutes. It's extra time is 5 minutes. Okay.
All right. Well, before we get there, I think the picture is clear. The criminality that you are guilty of, firstly, you're guilty of perjury because you lied about saying that you relied on gossip and you gave contradicting accounts of that. So it's a criminal offense to do that. It's called perjury. You understand that?
I note your comment.
Yes. The second criminality on your part is that having identified that Mr. Moyane was involved in what you call state capture and motive to get you demoted or taken out of your job, which you and I had agreed earlier that state capture, fraud and corruption, or at least can be synonymous. You failed to report that to the police and you breached Section 34 of PRECA. That's the second criminality. The third criminality, I'm sorry, you want to comment?
Oh, sorry, go ahead.
No. So, the third criminality is the one we're busy with now, which involves you having knowingly authorized a unit which is in breach of the intelligence legislation in this country. And I'm busy with that right now. Do you understand? I'm not saying you agree, but do you understand what I'm saying?
That's a strange question, Chair. I note what he's saying.
Yes. Okay, so can I continue now? So at page 354,
Chair, may I respond to those allegations?
Yeah.
So firstly, I deny that I perjured myself. Secondly, I think it's for you as the chair of the commission to decide whether Mr. Moyane is finally guilty of state capture or not. I made reasonable inferences at a particular point in time, which are fully justified by later developments. And thirdly, the IGI report, as I mentioned earlier on, is also discredited, reviewed, and set aside by a court of law.
Yes, yeah, but not on the basis that I'm questioning you. But anyway, that will be a matter for argument. The report says, this quote at 354, this in effect means that SARS, being an organ of state, should request intelligence from the agency, and it is not mandated to create its own intelligence collection capacity. The establishment of a capacity within SARS with the capability of exercising powers, objects, and functions which are exclusively reserved of the intelligence services is clearly illegal. And then the next, paragraph 5, it says, Mr. van Lochenberg, Mr. Pillay, and Mr. Gordan established this unit and recruited persons with a specific skill set to engage in activities outside the SARS mandate. And it was on that basis that the IGI proposed that you and the others be charged. Do you remember that? I know that it was, as you're saying, later reviewed. But at least the parts that I read to you were extant, or they were valid until that point, correct?
I will allow the answer, and then your time is up, Mr. Mpofu. Answer, Mr. Gordan.
So, Chair, in the first instance, very similar to Advocate Sikakane and his refusal to allow Audi, as the lawyers would call it, the Inspector General of Intelligence never interviewed me. There were 1 or 2 phone calls to try and set up an interview, but it never actually occurred. Secondly, as I said before, the IGI report was actually set aside. And thirdly, that was, in fact, as the Commission will note from the various evidence it has before it, the height of the period of state capture. And it's well known that the IGI office, or parts of the office, were compromised in that particular regard as well.
Chair,
Thank you.
So that's all I have to say, Chair. Thank you.
Chair,
Thank you.
I'm sorry, Chair, I really have to put this. I won't even ask for a comment, but it's for the record.
Okay.
If the chairperson can go to the first volume.
Well, if it's for the record, you can just mention what volume, what page, and then say what.
Chair, it's volume, you called it VE3, I think. Oh,
Yes.
Yes. It's the statement of complaint of Mr. Moyane, at page 1 thereof. And, well, the Chair will decide if you allow me to ask a question, but let me put something on record first.
Yeah.
That the statement itself, Chair, on page 1, you will see that it is headed as follows. The statement of complaint in order to satisfy, this is Mr. Moyane's, this is the celebrated complaint statement that was supposed to be motivated by state capture. Says, statement of complaint in order to satisfy my legal obligation to report allegations of corruption in compliance with the provisions of the Prevention and Combating and Corrupt Activities Act 12 of 2004. And all I wanted to establish, Chair, from the witness was whether he was aware that this statement, the genesis of this statement, was actually the fact that members of the rogue unit had confessed to Mr. Moyane, and as a result thereof, he, in discharging his own obligations, otherwise he would have been guilty of criminality.
I think you can place it on record in one sentence without asking questions.
Yes.
Yeah. Okay, all right.
Yes, thank you.
Okay, he won't need to answer. You can just place on record that that is your understanding of the position.
Well, so I cannot put the question?
No, don't put the question.
Okay, Chair.
Yeah.
Well, should I then elaborate
place it
what I was going to ask him? Yeah.
No, don't.
Okay.
Yeah.
This is, Chair, okay, that part that I'm referring to, and then I also want to refer to the one just above that, where it says, Mr. Moyane's statement said the state versus Elkhart Lombard, Johan de Waal, Ivan Pillay, Adrian Janse van Rensbeck, that is a gentleman who was known as Scully, and that Elkhart Lombard and Johan de Waal were the people who had confessed to Mr. Moyane about their involvement and that of Mr. Gordan in the rogue unit activities, including bugging the offices of the NPA. And then at paragraph 19 of that statement, which is the last one, the last paragraph, says, Mr. Moyane said, I hereby institute criminal proceedings against all individuals mentioned in paragraph 3 above, including those individuals who were in the line of command, and that would include Mr. Gordan, and knew or ought to have reasonably known of the illegal activities to be criminally investigated, face the criminal justice system and the rule of law in respect of allegations of corruption, money laundering, racketeering, conducting covert intelligence of the NPA,
I have to
and
stop
any
you there.
other charges which
Yes.
the SAPS and other prosecuting authority may deem fit. So
Okay.
that was the reason why the complaint was raised, Chairperson, not this mumbo jumbo about state capture motives that we've heard from Mr. Gordan.
Okay.
Thank you.
Somebody must sanitize the podium. We are at nearly 7:45. I'll give you a chance to re-examine, but maybe we should take a short adjournment before that happens. We'll take a 10 minutes adjournment. We adjourn.
Minister Gordan, are you there? Good evening, Minister Gordan, are you there?
I'm here.
Thank you. We're about to start. Thank you.
Thank you.
Ms. Leroux, we have got you, but we don't have your client. Okay,
You
Mr.
do.
Gordan is
You do,
there now. Yes. Mr. Gordan, your counsel will now conduct a re-examination to clarify certain matters.
Thank you. Thank you, Chair.
Ms. Leroux, how much time do you think you estimate you would need? I just want to have an idea so that we can see whether we...
Chair, I think it's probably going to be a little over an hour. I would think sort of an hour and 15. I'll try to do it as quickly as possible.
Yes, okay.
And I've structured it so that it's thematic and that we don't
Yes.
actually have to go to bundles
Yes.
and go to documents as much as
Okay.
possible.
No, that's fine, that's fine.
Thank you.
Okay.
Good evening, Minister.
Good evening, Advocate.
Minister Gordan, I'd like to clarify certain facts so that the record before the Commission is clear. And I'd also like to give you an opportunity to respond to certain themes and accusations that were made in the cross-examination. I've grouped these issues into 8 topics, and I hope to get through them quickly. So I'd ask that you answer just the question that I pose, and hopefully we can then make some progress.
That's fine.
So, Chair, the first topic I would just like to make sure we're absolutely clear on the record is exactly what happened with respect to the charge, to the complaint filed by Mr. Moyane.
Okay.
So, Minister Gordan, when you testified in November 2018 for the first time before the Commission, why did you think Tom Moyane had laid charges against you?
Because that was the narrative, firstly. Secondly, 2 former ministers, Mashlobo and Nhleko, said at a press conference in 2016 that Mr. Moyane had laid a complaint against me, and they named me specifically. They also made a number of wild allegations about R500,000 or a few 100 million rands being spent on equipment that was never actually true. And never found. And as you pointed out, Advocate, to the Chair earlier on, all this only emerged, the real facts only emerged once we had the affidavit made available by Mr. Moyane. So in the period between 2016 and when the affidavit lodged in terms of the complaint was made available, Mr. Moyane didn't actually take the opportunity to clarify that, in fact, I'm not one of the people against whom the complaint was lodged.
Thank you. Then, Chair, I'd like to move on to the second topic, which is there was a theme in the cross-examination, and it's a statement that Mr. Moyane has made repeatedly in his affidavits in the application to cross-examine, that he acted as a reasonable commissioner, that when he lodged the criminal complaint, he was acting as a reasonable commissioner. Tonight we heard that he also acted, and as the document makes clear, to discharge his obligation under PRECA. But he says that throughout this period, when he laid the criminal complaint, and then throughout your pursuit by the law enforcement agencies, that he had merely done his duty as a reasonable commissioner. And I'd like to test that proposition with you, because you were SARS commissioner for many, many years. And through that period, SARS has always been a target of attacks. So I'd like to explore with you, if you had been commissioner and certain things happened, how would you have reacted, so that the commission can evaluate Mr. Moyani's version that he was a reasonable commissioner, and Minister Gordan's version that he was furthering state capture. So the first example I'd like to cover under that is, let's just orientate ourselves in time. Mr. Moyani begins his term as commissioner on the 1st of October 2014. Less than 2 weeks later, on the 12th of October, the Sunday Times publishes its first story, SARS Bug Zuma, the start of what we now call the rogue unit narrative. If you had been commissioner and the front page of the Sunday Times had that story, what would you have done in response to that article?
Well, firstly, I would have asked the people mentioned in the article to explain the article to me. If I found that there was cause for concern, I would try to get somebody within SARS or an independent person to evaluate the facts first, and then establish whether there's a serious concern in this particular regard or not. And then, if necessary, either discipline the relevant individuals concerned if they've crossed the line, so to speak, or take whatever legal or other actions that I would be advised to take by a legal professional. And I'm confronted with this every other day in respect of one entity or another. But what became apparent, as you point out, is that subsequent to the 12th of October 2014, what was suspicious was the leaking of information from personnel files within SARS as well, about the pension matter and other matters related to some of the senior people at SARS as well. And the question is, well, if this is confidential personal information within SARS, who's actually leaking it? And why is this being done? And what is the context in which it is actually being done as well? So where necessary, investigations will be pursued. And if proper legal advice says that I must lay charges, then we will do so accordingly. A comparative example for reasonableness and as an action as a commissioner is, what did Mr. Moyani do in respect of Mr. Makwakwa? And in that particular regard, you had a dossier of some sort given by the Financial Intelligence Center to Mr. Moyani. And that dossier indicated that Mr. Makwakwa was receiving funds in his accounts from various sources. And it took Mr. Moyani, I think, some 4 months, only after this matter became public in one form or another, to reluctantly act on that matter. So if this was consistent practice by a consistent and professional commissioner of the South African Revenue Service, then there had to be even-handedness in terms of all of the matters. But what was interesting as well, which hasn't emerged, Chairperson, is the whole issue of one of these witnesses being asked to go. So KPMG is set up. I'm not sure whether it falls in the ambit of this. But again, just taking the theme of reasonableness and professionalism in one's conduct, a witness is told, pretend that you're sick and you're not available, but you've set up the KPMG investigation to be undertaken, and yet you're telling a witness to, inverted commas, play truant and play sick at that point in time.
Hang on, Mr. Gordon. Hang on.
Those are some examples.
Hang on. Ms. Leroux, if you want to compare the question of how one person or one commissioner would have acted in terms of reasonableness, shouldn't we look at the same facts if the same facts are known to them? I think that's much more helpful. Otherwise, we'll go into all kinds of scenarios. But in these facts, how would you have, if you knew these facts about this matter, how would you have reacted or acted?
Yes, Chair, and that was my question. If you had picked up the Sunday Times, what would you have done? The Minister said he would have talked to the people involved in the unit, he would have investigated the source of leaks, and he would have taken steps against them if it uncovered any wrongdoing.
Was Mr. Moyane aware of the Sunday Times
Yes, Chair.
article?
Yes.
Yes.
Has that been canvassed?
Yes, Chair. Because
Okay.
he takes certain steps on the back of the Sunday Times article.
Okay, if he knew that, then I
Yes.
think that may be fine. I wasn't
Yes.
sure that.
No,
Yeah. Okay, let's
on that
continue.
Monday morning, he took steps about that,
Okay.
accepting the truth of that story.
Okay, let's continue then.
Minister Gordan, do you know if Mr. Moyane spoke to any of the unit members after the 12th of October first article about the alleged unit?
Again, I can't give you absolute details, but I believe, well, Mr. Mpofu referred to two so-called confessions. I don't know the context and the actual content of the confessions by Mr. Lombard and another gentleman. The second issue that is in the media over time as well, Chairperson, is the truancy question, as I framed it earlier on. Pretend that you're sick and you're not available, so that KPMG can't question you at that point in time. I'm not sure what happened thereafter. And there might well have been other interactions that I'm not aware of.
And Minister Gordan will cover both of those topics. But do you know if Mr. Moyane ever spoke to, for example, Mr. van Lochrenberg, who was the manager of the high-risk investigation unit?
I don't know.
On the 9th of November 2014, there was the article that said the unit had run a brothel. It's common cause and in the public domain that Mr. Moyane disbanded EXCO as a result of that. It's also a common cause and in the public domain that the Labour Court overturned those suspensions. If you had read an article a few weeks after the first one that said there was a brothel being run, what would you have done as a SARS commissioner?
The same as I indicated earlier on, try to establish the true facts and whether these were just wild allegations, and again, understand the context in which the allegations were being made, and then decide the appropriate line of action, having consulted legal and other people within the SARS senior management team, who over the period from 1998 to the time I left in 2009, I had learned to trust in terms of their judgment and the advice that they would actually offer.
In the months that followed, the Sunday Times published more than 30 articles that made more than 50 different claims about the activities of the unit. These included accusations of murder, interception, break-ins, buggings, eavesdropping, members purchasing lavish cars and homes.
Hang on one second.
If you had been SARS commissioner, what would you have done with each one of these articles?
Sorry, Mr. Mpofu.
Thank you, Chair. I don't want to interrupt my learned friend, but where I come from, re-examination covers matters that were covered in the cross-examination, not new material that was not covered in the...
Chair, this isn't new material. The cross-examination...
Let him finish, Ms. Leroux.
Can I just finish talking? And these topics that are being covered, Chair, this is the second one I was waiting, hoping maybe we're going to move on. I don't know where it comes from about the 30 Sunday Times articles and so on, how that arises from the cross-examination, because that's new evidence, not even being given by the witness, but being given by my learned friend.
Chair, the cross-examination covered the reasonableness of Mr. Moyani's conduct when he went and laid charges. The cross-examination said everything he did when he was SARS Commissioner was not in furtherance of state capture, but was the conduct of a reasonable SARS Commissioner. We're testing that proposition with the examples of a slew of Sunday Times articles, and where Mr. Moyani does not respond to them, is that reasonable? That's what we're covering. I can move on from the media articles if you'd like.
You, Ms. Leroux, you're saying for the second time that you're testing something. The regulations say you re-examine to clarify, so which might be different from what happens in litigation. The purpose under the regulations of re-examination is to clarify matters that might not have, might not be clear, arising from the evidence that has been learned and the cross-examination that has happened.
Yes, Chair, and the cross-examination was not clear as to the basis for the contention that Mr. Moyani was reasonable. So we are clarifying and assisting the Commission by saying, let's look at what Mr. Moyani did. Was that, in fact, reasonable? Because you're going to have to make a determination testing. If he remains silent in the face of various things...
Well, let's go back to the question, and as you approach each question, if you can just bear in mind, I'll be asking myself, what is being clarified? That's what's going to be important.
Yes, Chair.
1 second, Mr. Mpofu, is there anything left?
Yes, Chairperson, again, I hope I don't have to do this again. Apart from what you have said, Chair, all I'm saying is that the evidence, quote unquote, is now coming from a learned friend about the 30 Sunday Times articles. Didn't come from the witness. That's a fact. The second thing is that re-examination, by definition, is the same as leading a witness in chief, because that's your own witness. So she can't lead the witness. She's actually doing worse than leading the witness. She's actually giving evidence. But she's not allowed to lead the witness, and she's not allowed to give evidence. That's all. And she must stick to clarification of issues that were raised in cross-examination. Thank you.
Chair, let me move on.
Yes,
we're wasting
please.
time.
Yes.
Minister Gordan, you testified that Tom Moyani had exculpatory evidence that he failed to share with law enforcement regarding the Pillay pension charges. Do you recall that evidence?
Yes.
What exculpatory evidence were you referring to?
I was referring to an opinion given by Mr. Flock Sivington in writing on whether the pension was acceptable in terms of the regulations that are applicable at the time. And the second one was an opinion by Mr. Mapakela, an attorney acting for Mr. Moyani, who specifically said that the pension issue is not of a criminal nature, and he wouldn't advise that complaints to criminal charges be laid in respect of the pension issue. And those were not made available to the NPA, as I understand it and remember it. And as a result, finally, on the 31st, I think, of October, Chairperson, in 2016, the then head of the prosecuting authority, Mr. Abrams, withdrew the charges.
Sorry, Mr. Mpofu.
Chairperson, really, this is more than frustrating. How can my learned friend ask for clarification on the Pillay issue? When I raised the Pillay issue on the 30th of November, she objected that it should not be part of the cross-examination. Today, you ruled, Chair, that it should not be, and I accepted that. So how on earth can she ask on that very topic that I was not supposed to question about? and now want clarification.
I understand your point.
I mean,
Ms.
this is
Leroux?
ridiculous.
Because, Chair, you permitted the question and the answer was given. Minister Gordan was not given the opportunity to explain what exculpatory evidence Mr. Moyani had before he filed the complaint. I'm asking him to clarify that for you.
So you say the question was asked and he answered.
Yes.
Well,
And but he was not given the opportunity to explain what
Okay.
exculpatory evidence on
Okay,
the pension
let's move
pillar.
on. Let's move on now. I've taken note. I can't remember. I thought I had said there would be no cross-examination, but you were listening. If you say there was a question and there was an answer before I ruled, so let's move on.
I'll move on,
Let's-
Chair.
Yeah. Okay.
Minister Gordan, you testified this evening about an opinion received from Advocate Trengrove regarding the lawfulness of the establishment of the unit at SARS. Do you know what that opinion said about the Sikakani report's finding that the unit was unlawfully established? Can we just get that clear on the record?
In essence, that Mr. Sikakani's understanding of the law was wrong. Secondly, that a distinction can be drawn between the kind of intelligence that an intelligence agency has the right to collect and have in its possession versus intelligence stroke information that a Home Affairs Department or a SARS or whatever other entity would have and need for its operational purposes. And in essence, if one takes it at a very practical level, if one says that SARS's role is to manage its customs activity in a way in which our borders are secure and illegal or illicit economic activity does not take place and smuggling doesn't take place, then clearly it needs information on who are the smugglers, so which warehouse are these cigarettes stored in, how are they distributed, so that excise taxes can be levied, and if need be, criminal charges laid. And that has happened in the past, if you look at the SARS annual reports.
Minister Gordan, do you know whether people involved in the management of the unit, and given that this is common cause, I think I can say it was Mr. Pillay, do you know whether his detailed rebuttal to Sikakani was ever provided to law enforcement by Mr. Moyani?
I'm not aware of the detail there.
You testified this evening about Mr. Moyani telling Helgard Lombard not to go to KPMG and telling him you are not well. Can we just start with who is Helgard Lombard?
I think it's one of the gentlemen mentioned in the complaint. So, Chair, your attention was drawn to page 1 of the bundle that Mr. Mpofu distributed, and he read State and Helgard Lombard, Deval, etc. Or he might not have read that part, he referred to the statement part, but Mr. Lombard's name appears as the first name in the affidavit accompanying the complaint.
Have you ever met Mr. Lombard?
Not that I can recollect.
Do you know anything about his time in the unit?
No, not the details. I mean, we have 15,000 people in SARS at that point in time, involved in various types of activity, as I pointed out to the chair previously, and to Judge Nugent as well. So the detailed operational activities of each of the individuals, I would not be aware.
To make sure the record is clear, do you know why Mr. Moyani appointed KPMG?
I believe there was a recommendation in the Sikakani report that some matters required further investigation, and that as a consequence, KPMG was appointed. And of course, Mr. Sikakani, as I recollected, did not entertain any submissions from the people who actually were part of the investigating unit. Then
you referred but weren't able to explain a reference to Mr. Moyani telling Mr. Lombard something like, "You are not well," and that he must stay home. What precisely was it that you were testifying about?
I've been told, Chair, that this event took place when Mr. Lombard was called. I can't remember which document I read it in now, but he was called, Mr. Lombard, then on the morning that he should have made his appearance before the KPMG investigators, one of whom I think was a Mr. van der Walt, and was told that he should say he is sick and go home. And I believe there's a recording somewhere that amplifies on this or illustrates this particular thing.
Mr. Gordan, were you ever interviewed by KPMG?
No.
Were you ever interviewed by the IGI?
No.
Were you ever interviewed by the Sukakani panel?
No.
Were you ever interviewed by Judge Kroon's panel?
No.
Were you ever interviewed by the Joint Standing Committee on Intelligence?
No.
Were you ever interviewed by the Standing Committee on Finance?
On this matter, no.
On the issue of the unit?
No.
So, Chair, to wrap up this theme, Minister Gordan, in light of the fact of what you've testified to with respect to Mr. Moyani's conduct with respect to KPMG, that you're unaware of him ever further exploring the Sunday Times articles, you were denied Audi by all of these bodies that made findings about the unit. Would you like to make a final comment about Mr. Moyani's contention that he acted reasonably when he laid a complaint against you? When he laid a complaint with law enforcement?
No, the only point I want to make, Chair, is that you should take note that all of the reports that Mr. Mpofu refers to earlier on were all reports that appeared to have a bias, did not entertain any counter views, if you like, or audi alteram partem being implemented. And in the KPMG instance, I remember on the 14th of December, when I had just taken over of 2015, when I was reappointed by President Zuma as Minister of Finance, saying in a press conference that KPMG's remark in some document or the other that I should have known about whatever it is that they were referring to in relation to the investigative unit was unacceptable, and I challenged them. And today, apparently, KPMG is sitting across the table and looking at settlements with the people that have been impacted as a result of their shoddy work in this particular regard.
Thank you, Chair. If I can then move on to the third topic, which is your conception of this concept state capture, because there were several moments in the cross-examination where you were asked to limit your definition for purposes of the question to criminality, and you answered things like you only partly agree that it's about that, it could have other aspects. Could you just explain to the Chair what you understand state capture to include?
I don't know if you really want him to do that. Last time under cross-examination, he provided quite some explanation, which I understood.
And Chair, you could refer to my original submission to you in 2018, in which I referred to a report by academics in South Africa. And of course, since then, I've learned a lot about the impact of state capture on institutions, including state-owned enterprises, on which you're getting evidence as well.
No, that's fine. What I'm saying, Ms. Leroy, it was quite clear to me what he said.
Thank you, Chair.
Yeah.
Then related to that, Minister Gordan, why is SARS important in the state capture project?
That, as I explained that earlier to the Commission as well, I mean, SARS is what you would call a critical fiscal institution that, in my experience, the Minister of Finance, when looking at a prospective budget will have some sense on the basis of macroeconomic data, which includes GDP growth, household consumption, gross fixed investment in an economy, the likely inflation scenario that will be provided by Stats South Africa, the view of the South African Reserve Bank on that particular matter, amongst other macro factors, and make an estimate of what it anticipates on the basis of previous year's experience, the kind of revenue it can anticipate in the future, firstly. Secondly, is the cost side or the expenditure side, which would be tailored to, in some senses, manage the gap, if you like, between revenue and cost or expenditure. Thirdly, the Minister of Finance and his team will have to look at the issue of borrowing requirements in a particular year, and the current Minister of Finance has made a number of public comments in that particular regard, and a particular framework then applies in relation to the borrowing requirements and the interest to be paid in respect of the debt that is actually owed. So revenue constitutes a critical part of the budget process, firstly. Secondly, the tax to GDP ratio, as I explained to you in 2018, Chairperson, is a very important part of establishing whether and what kind of tax compliance you have in a country. And there's evidence which showed that during Mr. Moyane's term of office, and this information comes from the Treasury, there was a decline in revenue, there was a decline in the tax GDP ratio, and some would say there was a decline in relation to the tax buoyancy issue. So SARS plays a critical role in ensuring tax compliance, in ensuring that all of us declare our taxable income, and that way government knows what it can actually spend on.
Now, one element of the cross-examination was that Mr. Moyane says you were jealous because he was the first commissioner to collect R1 trillion. Mr. Moyane is appointed in October. Could you clarify for the chair and explain how much credit Mr. Moyane can get for that R1 trillion in the first year?
I mean, R1 trillion is obviously an important milestone in the kind of context that we have in South Africa. I think when democracy came to South Africa in 1994, Chair, I think the collection was around a few hundred billion rands. To reach R1 trillion mark is a huge achievement. But as Mr. Cecil Modern, who was a Chief Director for Taxation in the National Treasury, said to the Nugent Commission, and this is where he describes the tax revenue buoyancy declining from 1.26 in 2015-16 to 1 in 2016-17.
Hello, one second, Mr. Gordon, Mr. Mpofu.
Chair, how is a witness now allowed to rely on a secondary source about a matter which was not dealt with in cross-examination? At the very least, to the extent that it was dealt with, he considered that Mr. Moyane was not only the first one to collect R1 trillion, but he achieved that feat again and again. And
yes, Chair, and I'm asking, and I accept.
Let Mr. Mpofu finish, Ms.
Can I finish, please? Yes. And that's the first part of the objection, Chair. The second part is the reliance on Mr. whatever his name is, that we don't know where that source is and what the credibility of that person.
Okay. Do you want to
Chair,
say
can I complete my answer?
Before you do so, let me hear what your counsel has to say to what Mr.
Yes, Chair. The cross-examination says one of the reasons why you can't say Mr. Moyane was part of state capture, One of the reasons you say that is because you're jealous he collected R1 trillion. So I'm clarifying and trying to understand whether R1 trillion can be to Mr. Moyani's credit. And that's what the witness is explaining.
Yeah, I think the question is legitimate, but just start your answer from the beginning, Mr. Gordon, and if you come to the point where I interrupted you, we will take it from there. I will see at that stage.
I'm sorry. I don't understand that ruling, Chair. How can the question be legitimate when it's based on a false premise? There was never, not me at least, nobody said in this commission that one of the reasons Mr. Moyano was motivated by state capture was because he was jealous. That the 5 issues that are raised in this commission, arrogance, petty jealousy, racism, deflection, and victimization of a whistleblower, were explained as a reason for the hostility between the two gentlemen. And so I don't know how...
And the jealousy, what was the context of the jealousy?
No, it was one of those 5 things which came from the hostility. So I don't know how you can uphold the ruling, the argument which is based on a false premise.
As I understood the position, certainly it had been said that, that's how I understood. It had been said or suggested that Mr. Gordon was jealous because Mr. Moyane had achieved the collection of R1 trillion, something that had not happened before. Okay, that part you agree with?
I agree, the Chair, yes.
Yeah.
Something that Mr. Gordon had never achieved.
Yes, that part you agree.
Yes, I agree with that, but I'm saying that was not, as my learned friend summarized when you agreed with her, that was therefore the reason for the...
You say in the way she had put it was different.
It was wrong, not different, but you upheld it, Chair. Okay. I'm saying that was a matter of the hostilities. I had traced the hostilities between them
among other things,
those, yes. Yeah. So at least let's uphold the correct thing.
Let me hear. It's all late. It's
and
been a long day for all of us.
Minister Godon's evidence has been, there was, to the extent there was hostility, it was because he believed Mr. Moyani was following out SARS to advance the state capture project. That's how they're connected.
Yes, but go back to your question about
so the question is,
the achievement.
I'm clarifying this issue that Mr. Moyani says, you were jealous because I got the R1 trillion. And I'm clarifying and saying, did Mr. Moyani in fact get the R1 trillion? Can he take credit for the R1 trillion? And the minister is explaining that it's inevitable because of inflation, because of the tax base, because of the economy, that someone would have got to R1 trillion. So it wouldn't be...
Okay.
So the...
Can Mr. Moyane take credit for achieving the R1 trillion collection? Mr. Gordon?
No, I've answered that already, Chair, with respect. And I said that the number is a good number to reach. And if I may, with your consent, just give you an illustration.
But just remember the
question. Somebody runs 100 meters 3 seconds ahead of the world record, you'll say that's a fantastic achievement. The point we're making here is a simple one. We are going to reach 1 trillion at some stage, we are going to reach 1.5 trillion at some stage, and we are going to reach 2 trillion at some stage. That's the logic of economic growth, that's the logic of inflation, and the level of tax compliance and economic activity you have within an economy. So it's a matter of jealousy and so on, I believe, is not a matter that we should even be looking at here, because there's nothing of that sort. What do I have to be jealous about? The logical development towards R1 trillion is a logical development that will happen whether Mr. X is there or Mr. Y is there at the end of the day. The question is, did you actually see an increase in the performance of SARS? Could there have been more than R1 trillion collected? Did the tax gap widen during that period? And the answer to all of that is very simple. Those things didn't happen, from the evidence I have seen.
So is your answer that Mr. Moane cannot take credit at all for that achievement, or is your answer that he can take some credit but not all the credit? What is the...
We'll give him some credit in a moment of generosity.
Thank you, Chair. That was the fourth topic. If I can move on to the fifth. Mr. Mpofu alleged, Minister, that you changed your statement to the Commission about meeting the Guptas. Chair, this was in the context of my learned friend's cross-examination that meeting the Guptas is a sign that you're involved in state capture. And he made the statement that you changed your statement to the Commission. The public record will record that at the time that you testified in November 2018, the EFF made this claim that you'd changed your statement. To be clear on the record, Minister Gordan, how many statements did you file with the Commission before you testified in November 2018?
One, as far as I know.
And how did it come about that your statement addressed the famous Ambani meeting where a member of the Gupta family may have been present?
I think I've said it here and I've said it elsewhere as well, that I had no recollection that a Gupta person was in that discussion accompanying Mr. Ambani. And for the umpteenth time, let me say that the meeting that I went to was a meeting between me and Mr. Ambani, who might have been interested in investing in South Africa. He was accompanied by people. Even today, I can't remember who was there. But the person who reminded me was my former Chief of Staff, currently the Director General of the Treasury, Mr. Mokajane. And he said, no, you're forgetting. This person was there. Well, I said, if you say so, I'll include it. And so I put it into my statement and then informed Parliament that this is how what I said to Parliament has to be changed because there's new information that my former Chief of Staff had made available to me.
Do you know how the EFF obtained your draft statement that didn't include the Ambani meeting?
No idea.
Chair, if I can then move on to the sixth topic, which is the unit. And it's important to just go through
Chair, again, this is not allowed. In re-examination, is not the time to mislead the tribunal or to put a question in a skewed fashion. This is what I said to Mr. Gordan on this topic at page 367 of the record. Okay, well, I'm putting to you then that you are asking because but you are avoiding to answer, which I do not understand, but one of the signs of meeting the Guptas, but let us move on. So you had changed your statement to the Commission to reflect that you did meet with the Guptas, correct? Minister Gordan, yes. The reminder that I received from me, my then Chief of Staff, who is currently the DG of Treasury, Mokajane. So he accepted that he changed his statement to the Commission. So I don't know what it is that my learned friend wants the witness to now say.
I'm clarifying that there was one statement that included that. To the extent that there's ambiguity that changing your statement means you had a statement and then you changed it. He had a statement and there was one statement filed.
I understood that what must have happened is that at some stage, whether in the Commission or in Parliament or elsewhere, Mr. Gordan had written or spoken on the basis of a certain number of occasions when he had met or with the Guptas or had been in a meeting where there was somebody from the Gupta family. But that later on, after such a statement may have been made, whether in the Commission or in Parliament, his then Chief of Staff or DG of National Treasury alerted him of another occasion when, which he said involved somebody from the Gupta family or associated with the Gupta family. That was my understanding of what had happened, of what the position is or was. Is that correct?
Can I clarify, Chairperson?
Yes, yeah. Yes,
May I do that?
yeah.
So I think you're right. Let's separate what happened in Parliament and what happened in preparation for the Commission, during which I met some of your legal representatives as well. So in preparing the statement, various drafts were prepared, and various people that were relevant to particular sections might have looked at it, or that particular draft or that section of the draft, to verify my memory. And it was in the course of that Mr. Mokhajane reminded me that this Gupta individual, whoever he might be, was present in a meeting. That meeting was the meeting with Mr. Ambani. So it was no meeting with Mr. Gupta. It was a meeting with Mr. Ambani where this individual was present. In the statement presented to you as the Commission and the chair of the Commission, that is the version that is there.
Was
So
there
there was no change in the statement.
also,
And that's
so
what my legal representative is making.
so there was no final statement, signed statement that you may have lodged somewhere, whether in Parliament, which had given a
No.
different number of contacts with the Guptas? Or-
No, Chair.
or
In
meetings?
Parliament, there's no such thing.
Yes.
That's why I'm separating Parliament and the Commission.
Yes. And so you say there was a draft which may
That is
have
draft
given a
preparation
different,
for you.
yes, a draft in preparation which had been prepared for submission to the Commission. But that draft included a different number of occasions. And
That's right.
subsequently, before that draft could be final, you were reminded by your chief of staff or DG about another incident. So the final statement that you signed was then
Yes.
different from what had appeared in the draft. Is that
That's
the
right.
position?
That's right. So there was no change in a formal statement to the Commission.
Okay, all right.
Thank you,
And
Chair.
any assertion, Chairperson, or attempt to mask this or obfuscate the reality, I've never engaged with the Guptas as the criminals in the state capture process have done. I've never been to their household. I've never met them on a one-to-one basis, except for when I was forced to, and I think even in my submission to you, I indicated one occasion when I visited President Zuma to discuss some other matter, and one of the Gupta brothers happened to be there, and we exchanged a few words about small business. That was the end of the story. So any assertion that I had anything to do with the Guptas is rejected in a complete and emphatic way.
Okay, all right. Mr. Mpofu, do you still have a problem?
Chair, this is not such a critical point, except that the Commission should not be misled,
Yes.
deliberately or otherwise.
Yeah.
I said at page 70, I said, I'm sorry, Mr. Gordan, if I interrupted you. The question I was asking you is that you denied meeting the Guptas. I agree you cannot remember the exact formulation, but when you answered the DA, you denied, correct? Minister Gordan, yes. Advocate Mpofu, thank you.
Yes, Chair, that was in Parliament. We're clarifying that there was only ever one statement to this Commission.
Yes, but that's why I explained earlier on. I said, you remember, I said, was my understanding had been that Mr. Gordan had made a certain statement, maybe in Parliament, maybe in this Commission, where he had given a certain picture or number of interactions. But then there was another statement where there was a different number of interactions.
Yes.
Now, if what Mr. Mpofu is saying is correct, then it's in line with what my understanding had been. So leave out the draft that Mr. Gordan is talking about, if what Mr. Mpofu is saying is correct, a statement was made, maybe it was a verbal statement and not a written statement in Parliament, which after his chief of staff reminded him of some interaction, necessitated a correction, as it were. So
Yes, Chair.
let me
that's-
clarify.
Yes.
Was there a statement in Parliament?
Yes.
And did that statement give a picture different from the statement that was filed in the Commission on the issue
On
of
the Ambani
interaction?
meeting, yes, Chair. And all I'm doing is clarifying that when Mr. Mpofu said, did you change your statement to the Commission, that we're clear that he means the statement you made once in Parliament, not you had more than one statement to this Commission, that you had
okay.
changed your evidence in this
Okay.
Commission. He's always been consistent in this Commission.
Okay.
When his Chief of Staff reminded him of the Ambani meeting, he included it in his one and only statement to this Commission.
Okay. Mr. Mpofu, it looks like...
Yes, Chairperson, as I said, I don't want to belabor this point. I think at least my learned friend now agrees that there was a difference, at least between the Parliament statement and the one given to the Commission. Now, I'm saying, and I accept that, but I'm saying the problem goes further than that, in that Mr. Gordan, in the previous answer that I read out to you, Chair, had considered to changing the statement of the Commission. That's a different matter. So if there were two changes, that makes it even worse. The statement in Parliament was made in 11th April 2016. The one change that I was talking about had happened 2 years later, 2018. So it can't be the same mistake every time the DG is reminding him about the same thing.
Chair, with respect, that's inaccurate.
Yeah.
There's one statement. Minister Gordon has explained that when he was preparing it for the Commission, his Chief of Staff reminded him of Ambani. He included it in the statement. So that is, in fact, the position. That's what his consistent evidence has been. We're just clarifying it. I can move on to the next topic.
Move on, yeah.
Chair and Minister Gordon, the next topic is various aspects of the so-called rogue unit narrative. Minister Gordon, you testified again this evening that there were two different units. There was the idea of one in the NIA that needed money approved by Minister Manuel, and then there was the actual unit that was established. It has had various names. Its last name was the High Risk Investigations Unit. Did you ever have anything to do with that unit's recruitment for staff?
No,
Do you know what its operations were?
not the details that I can remember now. No.
Do you know what all
But
of
I
its...
know the general, sorry, my apologies. Go ahead.
No, finish.
No, I was just going to simply say that this was, as I explained to the Commission earlier, and I've repeated many times, that customs and tax agencies around the world have these sorts of units. I think in my original appearance before you, Chair, in 2018, I think I said go to the website of the World Customs Organization, which I chaired for 5 years, and you will see similar references to similar types of units. So if one wants to put this accurately, this was an investigative unit. It wasn't a rogue unit. It was an investigative unit that was going to catch the rogues who were not paying their taxes and evading customs laws.
You testified this evening about something that's...
I just want to mention, it's 15 minutes before the expiry of an hour. I know that you said you could be a little more than that, but I'm just alerting you.
Thank you, Chair. Minister Gordan, you testified tonight about something called Project Sunday Evenings. This was the so-called bugging of the NPA. You were cross-examined about confessions that Mr. Moyani received from members of the unit. Do you know anything about a Project Sunday Evenings?
Not at that time. I've heard about it subsequently. I believe this was some work that Mr. Nell of the NPA asked certain people to do, but I have no knowledge of the details.
Have you ever instructed anybody to bug the NPA?
No,
Have you ever instructed anybody to bug former President Zuma's home?
no,
Have you ever instructed anybody to bug anybody?
no,
Have you ever instructed anybody to use a fake ID?
no,
Have you ever instructed anybody to undertake undercover operations?
I'm not sure what that means, but as I said, I didn't deal with operational matters.
When I say undercover operations, I mean operations where someone assumes another identity, a cover, and they infiltrate, for example, a smuggling ring. Have you ever instructed anybody to do something like
No,
that?
not my job to do that.
If I can then move on to the Sikakani panel report. You were asked repeatedly tonight and confirmed that as far as you know, that has never been reviewed in a court. Do you
Ms.
know?
Leroux,
Yes.
hasn't he explained the position very clearly on the Skakane report? I think he has said, to his knowledge, it may not have been set aside or it has not been set aside, but he said there are certain judgments which refer to it as discredited.
Yes, Chair, and I want to clarify why he says it's discredited.
Well, he didn't say it's discredited himself, well, maybe, but I think he was emphasizing that judgments said it is discredited.
Yes.
Chair,
Yes.
I don't know where the chair got that formulation of judgments. Which judgments?
He referred to judgments when you were cross-examining him.
No, he referred to one judgment.
Oh, well, maybe it was one. Yeah.
No, it's not maybe. It was definitely
Well,
one.
I'm saying maybe because, Mr. Gordan, was it one judgment?
I was quoting from paragraph 290 of the 7th of December judgment, Chair.
Oh,
The
thank you.
others were opinions of advocates, but only
Yes.
one judgment. Okay.
Yes,
No,
Chair.
on
One
the
judgment.
matter of the
Sorry, I'm
legality.
sorry.
Mr. Mpofu, he says one judgment.
Thank you.
Ms. Leroux?
Yes, Chair. Minister Gordan, you testified before the Nugent Commission. Do you recall what the Nugent Commission said about the Sikakani report?
Not the detail, I'm afraid.
Do you know of Mr. Mayani ever reviewing the Nugent report?
No, there have been various claims to that effect, but as far as I know, no review has been set in motion.
If I can then move on to the KPMG report, you described that as having been disavowed and that KPMG are now settling with people at SARS. Could you just explain what process you're referring to?
Well, Chair, there's been a number of engagements with KPMG. As you know, the previous CEO resigned, the new chairperson was appointed. I met the chairperson on one or two occasions, and then he seems to have disappeared. However, I believe there's certain staff who have suffered in terms of their jobs being lost and so on. Quite severe damage to their financial well-being and to their general well-being. Today, engaging in one way or another with KPMG and SARS to have some kind of reparation paid to them as a result of the suffering that they've been through. So that's what I'm aware of. And then I was referring again to paragraph 3 of the 7th of December judgment, which makes reference to the discredited KPMG report.
You also testified under cross-examination that you received an apology from Judge Kruin. Could you explain to the chair what that apology entailed? What was he apologizing for?
Well, in the first instance, for not applying his mind, as I recall it, to the Sikakane opinion independently, Secondly, for issuing some statement, I think at the time, on the basis of that, and he was rushed into it, it would appear by certain people who are now at the bar and elsewhere in South Africa. And thirdly, that he had wrongly said whatever it was that Sekakane said in relation to the unit. And that more importantly, he as a judge didn't put into practice the Audi alteram principle, meaning as you indicated earlier, or rather my response indicated earlier, he didn't come and ask me what's my view on the various matters that were being considered by the Kroon panel.
Thank you. If I can then move on to the seventh topic. Minister Gordan, the Snowman dossier was referred to in your cross-examination. It was in the context of it being the basis for the IGI report into the unit. This Snowman dossier, it's not the first dossier that has made allegations against you. Is that correct?
Well, there have been various dossiers over time. I don't even remember their names. There was another which made reference to Minister Nene, for example, at the time. What was it called? Spider Web or something like that. So that's part of the fake news industry as we now know it today.
And when you say the fake news industry, with respect to yourself, what allegations have been made against you that you consider to be fake news?
Oh, I'm supposed to have a very nice account in Canada, for example, with millions of dollars, which is non-existent, of course, and various such allegations, all designed to engage in counter smears, so to speak, or smearing my integrity and good standing, if you like, in an attempt, more importantly, to actually mask the nefarious activities of various individuals. And I referred to this, Chair, if you'll remember, in 2018 as well.
Do you know who the authors of these various dossiers are?
No.
Could you explain?
Some of them claim to originate in I beg your pardon, some of them
Yes.
seem to claim to be originating in the intelligence services. So you will recall that prior to my dismissal, or rather recall from London, when I was on an investment roadshow, was this alleged report, I forget what it's called now, that was shown to officials of the ANC at the time, and which had no foundation whatsoever, or was it the SACP? I'm not sure. But once that was discredited, that was set aside, and some other reason was found to cover up what the real reasons were for the dismissal of various ministers at the time.
Can you explain to the chair why you think you feature in all these dossiers? Why are you the target of all these different dossiers?
No idea. I seem to be popular for some reason. But clearly exposing corruption, setting into motion controls that will limit the possibilities of corrupt activity in various institutions, and such like activity is getting in the way of certainly the people who are extracting cash. But more recently, there was a claim made by Carl Niehaus in, I think, some press statement or the other, which said that I went out of my way, as did the Treasury officials, prior to Ms. Madonsela, now Professor Madonsela, completing her I think it was called the State of Capture report, and making funds available, which is a complete distortion of the truth. The truth of the matter was she did request more money from the Treasury. That money was not available. And what the Treasury often does with such requests and demands, if you like, is to actually help the people concerned, either a Director General or a Minister, interrogate their own finances and see how they could make savings on the one hand so that they could actually find the money to do whatever it is that they wanted to do. And that is the assistance that officials of the Treasury, not me, gave to the Justice Department and the Public Protector at the time to do whatever she wanted to do at the time. So this claim that I went out of my way, especially to make money available so that, for example, this commission would be set up to investigate state capture is absolute nonsense, to say the least.
And then finally, Minister Gordan, there was a lot of time spent in cross-examination making the accusation that you are racist. Could I ask you to explain to the Chair, given your history in the struggle, given the fact that you were detained and brutally tortured, given the impact
Ms.
on your
Leroux,
family?
didn't he explain that sufficiently, not only today, but last time under cross-examination? I thought he explained that quite well. I don't think there's anything unclear about what he was saying.
Yes, Chair, but I would like him to place on the record.
No, he has. It's clear. He referred to his role in the struggle. He referred to his membership of the ANC, if I recall correctly. He said quite a number of things. I'm not sure that there's anything unclear about where he stands or what he said about.
Yes, Chair, he testified that he is not racist. I'm asking him how it feels to be called racist on behalf of Mr. Tomoyani.
What does that
May I make a brief
clarify?
comment, Chair, so we can conclude this matter?
No, Chair, can I object before he makes any comment brief otherwise?
Chair, can I just explain the question?
Okay.
Mr. Moyani makes allegations.
Chair, I'm
of
on the
racism.
floor. Really, I can't stand this.
Okay,
This cannot
okay,
be happening for
okay.
the third time.
Mr.
Ms. Leroux
Mpofu,
must shut up when I'm
Mr.
speaking.
Mpofu, let me
Okay?
just hear before I hear you. Must you just hear,
You too, Mr. Koda.
Mr.
So,
Mpofu,
if,
just sit
I'm
down,
still
let
on
me hear her first.
the floor. You also shut up.
No, Mr. Mpofu, I'm in charge here. Please sit down. Let me hear first.
But I'm
what
still
she has to
talking,
say.
Chair. She butted in.
Yes, but she had not
So
explained.
why must I
and
sit
want
down?
to explain. I want to hear her explanation, then hear you. Then I'll.
But Chair, I'm
that
still
will be more.
speaking. Why must I be the
Yes,
one
but
who
Mr.
sits
Mpofu,
down?
I'm in charge here. I'm saying sit down,
Well, Chair,
please. I'll hear her and then I'll hear you.
Chair,
This Ms. Leroux.
maybe then we should leave because if we're not allowed to speak
I'm
and
telling you,
we allow interruptions,
Are going to be allowed to
No.
speak. Ms. Leroux, explain.
Thank you, Chair. Chair, a lot of time was taken up in the cross-examination contending that my client was racist. So that was when he first appeared in the cross, and this evening to try to extrapolate from the public protector judgments to try to make an accusation that he had treated the public protector in a racist fashion. It's true that Minister Gordan testified previously that he rejected the statements that he was a racist. I'm now asking that you give him the opportunity to explain to you and to the country, quite frankly, how he feels as a person when he is accused of being a racist by Mr. Moyani.
No, that doesn't clarify anything, Ms. Leroux. The purpose of re-examination under the regulations of the Commission is to clarify. I don't think
Chair, it's also to assist you in evaluating the testimony that comes out in cross-examination.
No, I've heard Mr. Gordan. He has explained himself, and I think sufficiently.
Then, Chair, that
Yes.
completes my re-examination.
Okay, all right. Thank you. I think we are going to adjourn because I think now that I haven't allowed the question, then there would be no objection.
no, Chair,
Yes,
there is.
yes.
I want to say, Chair, place on the record that it cannot be that Mr. Moyane and his legal representatives are treated like this in this commission. I was speaking, I did not interrupt when Ms. Leroux was making objections, and I'm in the process of making an objection. And I do not know on what basis I should be told to sit down when I'm still speaking and she has interrupted me. I cannot be interrupted by junior counsel when I'm still speaking and I need to finish my point. So I think it's completely unfair. I think it's uneven the way parties are get treated here. And I just wanted to place that on the record. It's completely wrong.
I am just going to say this. Yes, I did ask to hear what you had to say, but she wanted to explain, and I considered that it would be more convenient to have her explanation before I hear what you have to say. But we are going to adjourn the proceedings. Tomorrow we'll continue with the SARS-related evidence. Thank you to everybody for staying till late.
Thank you, Chairperson.
We adjourn.
Thank you.